I mean, it always seems to me there are three strands that have to be taken into account here. There's the industrial struggle, if you can put it that way, collective action, collective pressure on behalf of workers exerted by themselves through their trade unions. That's one strand. And then there's a strand which is in the hands of the lawyers, which is litigation, taking cases through the courts or defending unions or workers in the courts. That's the second strand. And then the third strand is changing the law, which is a political struggle done by lawyers and trade unions and, of course, workers and the electorate generally. So these three strands are interwoven because collective action, whether it's a manifestation or a strike or in whatever form it takes, can't take place, or it's difficult for it to take place without the legal space to allow it to happen. So, for example, in the United Kingdom in particular, we have very, very stringent laws about strikes and all sorts of legal barriers to taking strike action. So the law constrains and limits collective action, and it also makes it very easy for litigation to be brought against trade unions when they're trying to exert collective pressure. So it means that the strategy, whatever it is, has to involve also a political struggle to enlarge the legal space in which trade unions can operate. So I think from the perspective of the lawyer, it's important to be involved in all of these struggles to a greater or a lesser extent. I mean, obviously, as a practicing lawyer like you and I, most of our time is spent in the courts, either making a claim on behalf of workers or unions or defending them against claims by either the state or other employers. But I think we also have a role in, certainly in the political struggle, to enlarge workers' rights, to enlarge the space for trade unions legally to operate, and in also to support industrial action. I've found in the past that attending a picket line or going speaking to meetings of workers engaged in industrial disputes is obviously a great pleasure for me, but it also, I think, gives some support to and encouragement to workers to know that there are lawyers like ourselves who are prepared to stand with them. Obviously, there's not much we can do physically on but our presence is nevertheless, I think, important. So those are the three strands, and I suppose the conference or the webinar that we're now addressing wants to hear in particular about the litigation strategy, because the industrial strategy, of course, will be well known to the trade unions, and they don't need any lectures from lawyers about how to conduct industrial disputes. But so far as the strategic litigation is concerned, well, again, we've touched on it already, but there are two sides to that, aren't there? There's defending the unions and workers, in which case there's nothing strategic about it at all. One just has to fight whenever the legal attack comes. You've got to do whatever it is possible to do within the law in order to defend the workers and the trade unions. I suppose occasionally there are tactical considerations about whether certain legal arguments should be run or not, because if you pursued a particular legal argument, you might make the situation worse because it might encourage judges to make a ruling or a judgment which would be adverse for the future. But usually that doesn't apply when one is acting in defense of workers and unions. The strategic thinking is when you can advance the case of workers or unions by bringing litigation itself. So, so far as that is concerned, obviously the first place is in the domestic, the national courts of the country that you're operating in, and we all of us European lawyers have got a different situation in each country, and the scope of the argument is different. So there's not really much transferable knowledge there that we can bring. It's what happens when you get to the end of the road, really, when you can't take the case any further, and if particularly in situations where you've lost in the national courts, and this would apply whether you're defending or bringing a claim where you've lost, then the question is whether there are any international avenues to be explored. And of course, the answer is yes, there are avenues to be explored. And we're talking here mainly about civil claims, because I don't really do any criminal stuff, although criminal law is, of course, used against workers, particularly in picketing and demonstrations and that sort of thing. But in civil litigation, there are avenues, and they need to be carefully thought about. I think when you're litigating in the national court, it's instinctive. You know what the consequences of winning or losing a case or a particular legal argument are going to be. It's obvious. And usually the dispute that's on hand is going to take priority over any other consequences. But when you're litigating internationally, it's a bit different. Usually the dispute that has given rise to the litigation is over, it's finished. So that you're looking for the long-term consequences of your international litigation. And the long-term consequences can be enormous. I think when you and I have done cases in the European Court of Human Rights, you have in the back of your mind, and you wake up at 3 a.m. thinking, my God, if I lose this case, it could alter the balance of power for 800,000 workers across Europe, 800,000 workers across Europe. And these are big consequences to weigh. And of course, it's not just for the lawyer to make those, solve those equations. It's for the lawyer in conjunction with the trade unions who are instructing the lawyer. But
John, it would be good if you could elaborate on one case that you think of particular importance, and that you maybe explain how the discussions with trade unions were to bring this case to the European and international level, a case that comes to your mind and that can be useful to learn some or to draw some lessons of that case.
Yes. Okay. Well, just before that's a good idea. Let's examine a couple of cases. But before we do that, let's just touch on the particular international avenues that are available and say just a brief word about each one. At European level, of course, we've got the Council of Europe, which has under its wings, as it were, the European Court of Human Rights and the European Committee on Social Rights. So the European Court of Human Rights is the supervisory body for the European Convention on Human Rights, and the European Committee on Social Rights is the supervisory body for the European Social Charter. So these are two obvious avenues. Now, one of those is shut off for us in the United Kingdom, and that's the European Social Charter, because although the United Kingdom has ratified the relevant articles of the European Social Charter. And here we're thinking about Article 5 and Article 6, which protect collective bargaining and the right to strike and so on. Although the UK has ratified them, what the UK has not done is to ratify the collective complaints protocol, which means that British trade unions cannot bring a case to the European Social Charter. They can make comments to the annual review conducted by the committee, but it's not as satisfactory as making an actual complaint. Now, I've had the privilege of making such complaints, but on behalf of the Irish Confederation of Trade Unions, because the Republic of Ireland has ratified the collective complaints protocol. And I'll mention that case in a moment as an example to look at. But what we do have in the United Kingdom, as you do in Belgium, is access to the European Court of Human Rights. And of course, there are a number of articles which are relevant to issues which arise in labour law. But of course, the most important one is Article 11, the freedom of assembly and freedom of association, including the right to belong to a member for the protection of one's interests. And that is absolutely crucial because it protects the right to collective bargaining, the right to be a member of a trade union, and various other rights. At more international level, of course, there's the ILO, the International Labour Organization. And there are two avenues here. I don't want to go into technicalities this afternoon, but just to mention those two possibilities. One is to lodge a complaint to the Committee on Freedom of Association, which is a tripartite body like the ILO itself, consisting of representatives of governments, employers, and workers. And that meets 3 or 4 times a year, and it's easy to lodge a complaint. You just have to send a letter to the Director General saying that you're making the complaint. And of course, your union will be liaising with the workers group at the ILO to talk about when that ought to be lodged and the terms in which it ought to be written and so on. The difficulty with that avenue is that it's a political committee, and there's what we say in English, horse trading. There's bargaining behind the scenes, which mean that some complaints are more successful than others, even though the legal merits appear to the outsider to be identical. The other avenue is to make a complaint. It's not called a complaint, but whatever it's called, send a letter to the Committee of Experts on the Application of Conventions and Recommendations. And this is a quasi-judicial committee which meets once a year, which considers in rotation each country's compliance or non-compliance with the conventions it's ratified and with the fundamental conventions of the ILO, which of course include 87 and 98 on collective bargaining and freedom of organization and so on, the right to organize. That's the most independent means of accessing the ILO, but timing is crucial there because they meet in November. And if you haven't got your complaint in by July, you'll miss the boat for until next year. And now they have so much work to do that they don't always look at all conventions each year. So those are the options that you have to consider. So let's consider a couple of cases then. Let's take the last one that I did, which is the complaint to the European Committee on Social Rights on behalf of the Irish Confederation of Congress of Trade Unions, ICTU. Now, this case you can read about. It can be downloaded from the Council of Europe European Committee's website, ICTU against Ireland. I can't remember what year it was, last year, or maybe it was the year before, 2018, I think it was. The issue in that case was that Irish unions representing freelance workers, journalists, musicians, and actors, freelance actors, had negotiated with the respective employers' associations and agreed terms and conditions under which the freelancers would work. The European Commission then stepped in and threatened a €4 million fine if either the employers or the unions insisted on the collective agreements that were to apply. So this, and the basis of this is that freelance self-employed workers are notionally undertakings, and therefore any agreement between undertakings to fix the price on which they sell goods or services is in breach of European Union competition law. Now, in fact, since that case, the European Commission is backing off that attitude, and it looks as if there'll be some movement to grant a much wider exemption for freelance workers. But at the time, this was a very, very serious threat all across Europe in those professions and many other professions like construction and so on. And we had the idea that we'd lodge a complaint under the collective complaints procedure to the European Committee. And on the back of that, the Irish government then introduced legislation which would have exempted these workers under various conditions from Irish competition law, which of course, like every other state, is identical to European competition law. It has to be, it's derived from it and must comply with it. But we nevertheless persisted in our complaint, and the European Committee found that the right to collective bargaining was absolutely a fundamental aspect of Article 6 of the European Social Charter, and there was no exemption for the self-employed, who are equally entitled to that right. And they only let the Irish government off because of this legislation that had been introduced. And the importance of that case is obvious. If for freelance workers, for musicians, journalists, and actors, I needn't go into the consequences of it. But what is also important is that simply bringing that case highlighted the situation right across Europe, and hundreds of thousands of workers benefited by that case, which was then used in domestic courts, national courts, saying, look, you're trying to stop us you're trying to stop us bargaining collectively. This case says that everybody's got the right to bargain collectively. And so it was used not just in the circumstances of competition law, but where other restrictions have been placed on collective bargaining for the self-employed. Indeed, I used it in a case in the British Court of Appeal only a month ago on behalf of Deliveroo workers who were barred from collective bargaining on the basis that they were self-employed and were not providing personal services under their contracts. We failed in that argument, but that's to do with British national law. But the point is that these arguments, if won in an international forum, can then be used more widely by comrades in other countries. And the other lesson that I think is demonstrated by that case is that because of that litigation brought by the Irish Congress, the Irish government felt that it had to bring in legislation to overcome the problem, because it was an embarrassment to Ireland to be held up as a lawbreaker in an international forum. So it had implications in all three of the strands that we opened our conversation with.
Okay.
So you were thinking about some other cases that I've done. Most of my cases, probably like your own, you may be more successful than me, but most of my cases have been heroic defeats. But at least we've shown the flag and gone down with all guns blazing. But in particular, in the European Court of Human Rights, we had a run of a couple of cases that were successful, and then the European Court of Human Rights, because it's constantly changing personnel and constantly changing political pressures, and which derive from the nature of the countries which send judges. I mean, all 27 countries in the EU have a judge in the European Court of Human Rights, where you can imagine well, you know, Jan, but the Polish and the Russian judges are not progressive. And this, of course, affects the outcome depending on which judges you get, but it also affects the overall political outlook of the European Court. And we've had a situation in Britain where for the last at least 10 years, well, say 10 years anyway, the British governments have been threatening to denounce the European Convention, which is a prospect that the European Court of Human Rights does not like. And I feel that that's affected their judgments in relation to the United Kingdom by not wanting to give ammunition to the government or justification to leave the European Convention. And so cases that have been brought on behalf of trade unions have failed in the last few years. But I give you a couple of examples to show the sorts of cases that can be brought. One is a case that we brought on behalf of RMT, which is the Rail, Maritime and Transport Workers Union. And this was a case which I'd wanted to bring for a long time, which was to challenge the ban on secondary industrial action in the United Kingdom. All forms of secondary industrial action are prohibited in the UK, which means that you can only have a legitimate trade dispute with a direct employer of the workers concerned, which is a major problem when you have outsourcing or privatization, because of immediately you've got workers who belong to another employer. So I wanted to challenge this, and my great friend, the then General Secretary of the RMT, Bob Crow, who I think is known to the Belgian railway workers at least, unfortunately died a few years ago, but he and I decided that this was a case that ought to be taken if we could find the appropriate facts to bring the case on. And it turned out that after a wait of a couple of years or so, those facts did occur in an industrial dispute on the railways, and we took that case. Now, unfortunately, it was one of those that lost, and the judgment for law students is well worth reading, because it is hard to discern any legal logic behind the reasoning of the court. It's a completely artificial judgment, which simply doesn't do justice to the fundamental right to be a trade union, which to be a trade union member, which the European Court have said on many occasions, in many cases, must be effective. It must be an effective right, and restrictions on it mustn't render the right nugatory. And the ban on secondary action is such denies workers the right to take industrial action, which is a fundamental aspect of being a trade union member.
Before talking on other cases, maybe I